And Christophe, the floor is yours.
Yes, so welcome to everyone for this meeting on the UN Declaration on the Rights of Peasants and the right to seats in Croatia. We have a research project and we do many activities in Brussels and in many countries in Europe on the right to seats since 5 years now at the Geneva Academy with many partners, including Fulia Batour and Karin Pechard. They are both associate research fellow at the Academy since a few years. So we are very happy to be with you today to discuss the situation of Croatia and what the reform that will happen at the EU level will bring to this discussion on the right to seats in Croatia. So the first person who will speak is Karin Pechard, who will speak about the UN Declaration on the Rights of Peasants and the right to seats, which links to EU seat, which obligations for the EU and its member states. Karin, you have the floor.
Thank you very much, Christophe. Welcome to everyone. What I'll do in the time I have is that I'll give some background into the Declaration on the Rights of Peasants and other people working in rural areas. And then I'll talk in more detail about its Article 19 on the right to seeds. So the idea of having a declaration on the rights of peasants goes back 20 years and came from the peasant movement La Via Campesina. La Via Campesina discussed this project internally, the idea of having a declaration on the rights of peasants, and adopted it in 2009. Now, that was in the aftermath of the 2008 World Food Crisis, and La Via Campesina brought the project of a declaration at the time to the UN Human Rights Council. So negotiations started in 2012, and it took 6 years for the declaration to be adopted, first by the Human Rights Council, and shortly after that by the UN General Assembly in December 2019. Now, it's important to say that Article 19 on the right to seeds was one of the most debated and controversial articles during the negotiations. Article 19 is one of the reasons why many European states were against the declaration from the beginning, and also why they abstained from voting on its adoption. And one of the main reasons why this article was controversial is that many of the rights that are recognized to peasants in the declaration are already established in other international human rights agreements or instruments. Whereas in the article on the right to seeds, there are new rights in international law, and that's always more controversial. So when the vote was taken at the UN General Assembly in December 2018, overall 121 states voted in favor of adopting the declaration, 54 abstained, and 8 voted against. Now, if we look at the EU, most EU member states, including Croatia, abstained from voting. Only 2 voted in favor, Portugal and Luxembourg, and 3 voted against, the UK, Serbia, and Sweden. And now let me share my screen so that we can look at the text of the declaration together. Just a second. Okay. So it's important to know that how states vote on the adoption becomes irrelevant once a declaration is adopted. If you look at the text of the declaration, it says here that the General Assembly invites governments, agencies, and organizations of the United Nations systems and intergovernmental and non-governmental organizations to disseminate the declaration and to promote universal respect and understanding. And this is in line with the need for member states to apply international agreements adopted by the UN General Assembly in good faith. Now, let's look at some of the provisions, some of the articles. First, I'll skip the preamble and go directly to Article 1. So Article 1 provides a detailed and inclusive definition of peasants. It defines a peasant as any person who engages in small-scale agricultural production for subsistence or for the market, who relies significantly on family or household labor, and this is very interesting, who has a special dependency on and attachment to the land. Article 1 also says that the declaration applies to any person engaged in artisanal or small-scale agriculture, crop planting, livestock grazing, pastoralism, fishing, forestry, hunting or gathering, and handicrafts related to agriculture or a related occupation in a rural area, as well as to their dependents. It also applies to indigenous peoples and local communities, and finally to migrants and seasonal workers. Now, I also want to draw attention to Article, I skipped 2.4 here, which is highly relevant to our discussion today. So this article says that states shall elaborate, interpret, and apply relevant international agreements and standards to which they are a party in a manner consistent with their human rights obligations as applicable to peasants and other people working in rural areas. This is reinforced in Article 19.8 here, which says that states shall ensure that seed policies, plant variety protection, and other intellectual property laws, certification scheme, and seed marketing laws respect and take into account the rights, needs, and realities of peasants and other people working in rural areas. So read together, these two articles mean that states must apply international agreements in the area of intellectual property and seed marketing in accordance with their human rights obligation under the declaration. In other words, IP or seed marketing laws must not lead to violation of the rights of peasants because human rights take precedence over other types of legal norms. And now let's look in more detail at Article 19 on the right to seeds. We'll come back to the beginning. I won't go through Article 1A to D, the first part here, because they're very close to the text of the farmers' rights provision of the plant treaty that was adopted at the FAO in 2001. They reproduce almost word by word Article 9 of the plant treaty. So these are the provisions on the protection of traditional knowledge, on access and benefit sharing, on the right to participate, and on the right to save, use, exchange, and sell farm-safe seeds. But, and that's where it's interesting, the declaration goes further than the plant treaty. If we look at point 19.2, peasants and other people working in rural areas have the right to maintain, control, protect, and develop their own seeds and traditional knowledge. And then starting with 19.3 all the way to the 19.8, Article 19 defines state obligations related to the right to seeds. So I'll read them. 19.3 states shall take measures to respect, protect, and fulfill the right to seeds of peasants. 19.4 states shall ensure that seed of sufficient quality and quantity are available to peasants at the most suitable time for planting and at an affordable price. 19.5 states shall recognize the right of peasants to rely either on their own seeds or on other locally available seeds of their choice and to decide on the crops and species that they wish to grow. Point 6 is interesting because it refers explicitly to peasant seed systems. It states that states shall take appropriate measures to support peasant seed systems and to promote the use of peasant seeds and agrobiodiversity. And this is important because states have supported commercial seed systems for decades, but peasant seed systems have not received any support of that sort. So this is an official recognition of the value of peasant seed systems. Then 19.7, states shall take appropriate measures to ensure that agricultural research and development integrates the needs of peasants and to ensure their active participation in the definition of priorities and the undertaking of research and development, and also increased investment in research and the development of so-called orphan crops and seeds that respond to the needs of peasants. Now I'll stop sharing. And now I want to address a point that keeps coming up whenever we talk about the declaration, and I'm sure some of you have been wanting to ask. So you'll sometimes hear that the declaration is not legally binding. Now, this is true in the strict sense that it is a declaration, it is not a treaty, so it is not formally binding in the way the plant treaty is, for example. However, that does not mean that the declaration has no legal weight. On the contrary, So first of all, the declaration is part of international human rights law, and human rights are the highest legal norms in the international legal system. In fact, the declaration is already being used as a source of law in court decisions on peasants' rights and the right to seeds in some countries, and I'll give some examples in a moment. Second, the declaration is an interpretation of the right to food, which is a basic human right that EU countries recognize. So the International Covenant on Economic, Social, and Cultural Rights and the Convention on the Elimination of All Forms of Discrimination Against Women are two binding international treaties that protect the right to food, which has been interpreted by UN experts as including peasants' right to seeds. And third, the declaration makes it possible to use existing human rights mechanisms to monitor its implementation. These mechanisms include the Human Rights Council, the UN Special Procedures, so for example, the UN Special Rapporteur on the Right to Food, and also the UN treaty bodies, for example, the Committee on Migrant Workers or the CEDAW Committee. And as I said, the declaration is already being used as a source of law in court decisions on peasants' rights in some countries, including, for example, recent cases in Honduras and Ecuador. So, for example, in Honduras last year, the Supreme Court declared the new plant variety protection law unconstitutional because it would have violated peasants' right to food and to seeds. And the judge explicitly referred to Article 19 and 20 of the UN Declaration in his decision. So we've seen Article 19 on the right to seeds. Article 20 is on the right to agrobiodiversity and the protection of traditional knowledge. If you're interested in reading the decision, it has been translated into English by Aprebes, and we can send a link in the chat. And the other example I want to give is Colombia. So in Colombia, the government introduced a bill in Congress last year recognizing peasants as rights holders. And this bill also provides for the integration of the declaration into the Constitution. That bill was approved at the end of the year. And this means that the declaration is now legally binding in Colombia. If you're interested in finding out more about the declaration and its implementation, there is a website that was launched a few months ago that is dedicated to precisely that. So you can see it here, and we can also send a link in the chat. It's called Defending Peasants' Rights. And so to conclude, farmers' rights were recognized in international law with the adoption of the Plant Treaty 20 years ago. But the significance of the UN Declaration is that the right to seeds is now recognized in international human rights law, that the rights holders are clearly defined by the UN Declaration in a very inclusive manner. Third, that the different elements of the right to seeds are specified. And finally, that the declaration also stipulates state obligations in relation to the right to seeds. And this is why it is important to use the Plant Treaty and the UN Declaration in conjunction, because they're mutually supportive and they're complementary. So I'll stop here and I'll let Fulia explain to us the relevance of the UN Declaration in the context of the current reform of the EU seed marketing legislation. So Fulia is a consultant with Kibele and a research associate at the Geneva Academy, and she's also an expert on the EU seed legislation. So Fulia, the floor is yours.
Thank you. Thank you very, very much, Karine. And now, since she has introduced the UNDROP declaration so brilliantly, I want to put it in the EU seed policy context. So as you have seen, the UNDROP as an instrument of human rights is a very holistic document, especially in its approach to peasants' rights in general, but also their rights to seeds. And therefore, the rights that are recognized in the declaration are affected by numerous laws. So you have those who pertain to ownership of seeds and resources, whether we're talking about intellectual property rights, so which provide monopolies for invention, whether we're talking on UPOV style plant variety protection legislation, or patents that are granted at European and national level, but also everything that relates to traditional knowledge, access and benefit sharing related to the use of genetic resources. The UNDROP rights are also affected by everything that relates to plant and food safety. So whether it's about plant seed health, which is the rules of which are in a different instrument in European law, a standalone regulation, and everything that relates to food safety. So the cultivation, introduction, and import of genetically modified organisms. The focus we have today is rather on the third big family of legislation that impacts the UNDROP rights, and that is seed marketing, which is only about the EU common market and the conditions for the sale of seed. So there are elements of seed health inside, but seed health is now addressed in a standalone document and a standalone binding piece of legislation in the European Union. So how does seed marketing legislation impact UNDROP rights? You have 5 different rights that are actually directly and indirectly impacted by seed marketing legislation. So it's the right to save, use, exchange, and sell their own seeds for peasants. The right of peasants to maintain, control, develop their own seeds, the right to have access to locally adapted seeds, the right to participate in decision-making, and the right to the protection of traditional knowledge and the sharing of benefits that arise from the use of such knowledge. What I think is quite interesting in the declaration is that it's not just about farmer seed systems and the informal seed system, as the literature usually calls it. It's also about diversifying the seed market, the common EU seed market and the national seed market, so that it also responds to the needs of peasants that are very different than the needs of commercial scale industrial seed producers, seed multipliers, and breeders. Okay. What we have as rules in the EU right now, they're all contained in 12 directives. A directive is a European law that is not directly applicable, contrary to the EU regulation. So these directives need to be transposed in the 27 member states. So that means that on their own, the directives create rights and obligations, but they need a second step to actually have the legal effect that they wish to have. Member states need to do this, otherwise they are assigned to the European Court of Justice by the European Commission. In essence, so as a conclusion, we have 27 different national seed marketing regimes, because when the states transpose these directives, they have a little bit of margin of maneuver that impacts the UNDROP seed rights quite generally and quite extensively. The principles of the legislation, the EU legislation, is based on mandatory pre-marketing registration and control, whether usually it's a registration of the variety before the seeds of that variety can be sold on the market. Sometimes it's registration of the operator and a listing of the variety, like in the case of fruit species. You have rules on seed quality all the time, so on seed production, whether it's like minimum humidity rates, etc., or seed lot certification, which is usually mandatory, but with some exceptions. And then you have rules on labeling, sealing, and the control of all of these requirements. This legislation came to be at the European level, at least in the 1960s, and the goal of the legislation is clearly to ensure the identity of the seeds that farmers were buying, their quality, but also productivity objectives. We are in a context, so post-war, it's on a crisis of underproduction in the agricultural sector. So there's this idea to boost production and productivity. So what do you have to ask yourself? So what's the room now for UNDROP seed rights inside this? The 3 questions that you should ask. One is, are seed exchanges and the sale of seeds between farmers considered as seed marketing? If it is considered seed marketing, then you would need to comply with all of the legislation. So register the variety, ensure that the seed lots are certified, especially in cereals, and then label your seed accordingly and your packages accordingly. Can farmers develop their own varieties and then sell them? So do they have access to the market themselves? And does the seed market cater to their needs? So do you have enough varieties or types of varieties, essentially, that correspond to the needs of peasants and not just industrial farmers? And third big question is whether there is governance, or there are governance mechanisms that ensure that peasants participate in decision making. The answer to those questions is not as straightforward and positive as you would like them to be, even if the entire legislation has evolved quite a bit from the 1960s onwards. So in the 1990s, a lot of changes were made to the EU seed marketing legislation to conserve genetic resources and to open up a bit the rules which were strictly delineated in the 1960s. So you have things in the EU seed marketing legislation that can go in the sense of UNDROP seed rights, but only in derogations. Okay, so it's when peasant seed systems are excluded from the scope of legislation, so you don't have to actually register the varieties, etc., that they're recognized through an exclusion, or through a big derogation, which concerns the registration and sale of seeds from conservation and amateur varieties. Okay, so is exchange and sale of seeds marketing in the EU? There's no one answer. It's very different. In Denmark, non-commercial use is not viewed as marketing, but if you scale it up, for instance, if you sell it in a horticultural shop or something like this, then it becomes marketing and you need to register the varieties and certify the seed lots. In Estonia, up until very recently, all seed exchanges, even between non-professional people, so even between non-farmers, just gardeners, were viewed as marketing. The European Commission tends to see it this way, but not that extreme, but it's very close. In France, for instance, the situation is completely the opposite. All the sale of seeds that are in the public domain to non-professional people, so to amateur gardeners, is considered to be out of scope of the legislation. Okay, so if you're a peasant catering to private gardeners, multiplying seeds for private individuals, you won't be concerned. You're not concerned by the legislation in France. Second big question is whether the marketing of locally adapted varieties for low input, i.e. peasant agricultural conditions, not just the US, allowed. It is through a derogation to the big criteria of distinctiveness, uniformity, and stability, which is the main entry point for the registration of varieties. So you have conservation, amateur varieties, as I mentioned, for vegetable species, and then the new organic heterogeneous material system through a notification, okay, and not through a registration with official controls, etc. So there are spaces, but those spaces actually provide very little margin of action in terms of peasant seed systems. It doesn't really recognize farmers' knowledge and farmers' also breeding capacity, or actually the will to breed. And most marketed varieties, even if you have a lot of varieties that are registered in the EU, they do not necessarily correspond to the needs of peasants and the context in which they produce food, seed or food. So we are going towards a reform of all of this. It's the second time around. The first time was 10 years ago. It didn't go well for the proposal, which was rejected by the European Parliament. But I think it's 6 years after its formal withdrawal by the Commission, the European Council, which is the member states of the European Union, requested the European Commission, who is the guardian of the treaties and is both the executive leg of European policymaking, but also has the right of initiative. So the member states asked the Commission to do a study on options to reform the EU seed marketing rules in November 2019. Then in 2020, the Commission started a consultation and a study which was done by an external consultancy to see essentially if the legislation had to be changed or if we could go on with the system as we have today. And in April 2021, after all of that work, the Commission issued a working document which concluded that the legislation was not fit for the European Green Deal and the Farm to Fork strategy. So these are two non-binding documents that set at the very beginning of this new Commission, which only has 1 year left to finish all of its program, that set its political priorities, and the political priority was the European Green Deal with targets on the increase of organic land, decrease of pesticides, a lot on nature restoration, and in the Farm to Fork, a desire to change essentially the seed marketing legislation to allow the marketing of more traditional varieties. Okay, it doesn't mention peasants in the working document, but indirectly, they hint at the fact that there will be things that are useful or positive for peasants. In June 2021, we went through an inception impact assessment with policy options for reform and an impact assessment process where we're not sure yet whether the socioeconomic and human rights impacts of the proposal have been assessed a lot in detail, but we'll see when the proposal is published on the 5th of July. It's accompanied by the impact assessment, and we'll see if there's a human rights chapter inside. And probably we're going to get a regulation which has direct effect that will be divided into crop species so that it caters to the needs of different sectors. And then the negotiations start with the Council of the EU, so member states, and the European Parliament directly elected. And on the same day, we're also expecting a proposal from the European Commission on new genomic techniques, which is CRISPR-Cas. Usually people understand it a bit better. So it's a bit wider than CRISPR-Cas, but it will change a little bit, modify, or we don't know. But that's the goal, I think, to modify the current food safety system we have for GMOs and have a bit of a different, maybe, risk assessment authorization process for products developed using new genomic techniques. So I mentioned the inception impact assessment. The European Commission had put different policy options on the table. So one was do nothing, because they always have to compare to the status quo. The option one was very light, so we're not changing too much, but we're tweaking. Option two was very flexible with a lot of sustainability elements to it. And option three was full harmonization, more than flexibility, but with high user guarantees. So no more derogations, no more conservation of varieties, etc. It was a very big mixed bag, and true, I think, very good awareness raising activities with authorities and the European Commission. We now know that it will be a mixture of different policy options, but option number two, which was the most flexible for UNDROP seed rights, will be quite present. In terms of the scope of the legislation, we know that there will be rules for farmer seed exchange and sale, which will be limited probably by quantities, but at least there will be rules that say, okay, even if farmers as professional operators exchange and sell seeds, even if they're professional operators, we're not going to view this as marketing, and they don't have to register all of the varieties they exchange, and they don't need to certify all the seed lots that they exchange and sell. There will be probably, as maybe also counter effect of that, the need for all operators to register with a threshold, possibly for only professional seed producers, which is already the case under the plant health regulation, which applies only to the movement of seeds, not only. It applies to all movement of seeds, not just marketing. And then there will be an exception in the scope of the seed marketing legislation for seed savers, conservation networks, who will not have to go through all the variety registration process all the time, and probably some criteria for the species that are regulated at European level. Then on access to market and variety registration, we know that there will be one single regime, which combines all of the derogations that exist today to include everything that was already or is today considered as conservation varieties, but also allowing heterogeneous populations and material, not organic, to be marketed through that route, old varieties, heirloom, traditional local varieties. I mean, everything depends on the language used, but I think this is the main idea that the Commission is going for. There will also be easier access for organic varieties, how testing of varieties and also seed lots will be done under organic conditions is not really known, but under the European Green Deal, they have to facilitate that testing. And another element that comes also from the European Green Deal is that they want to add a sustainability assessment in the mainstream registration route. But will that be included in the VCU tests, so the tests that are done for cereals, for the assessing the value of the varieties for the cultivation and use? Only in certain species, in all will be an ad hoc assessment. We don't know. And the last thing that we're sure of is that the amount of controls that can be done under official supervision, so by operators that are allowed to do controls, will be much higher than it is today. So that's also aligned with the regulation on official controls and the regulation on plant health, which allows for this authorized operator concept. Okay, and the fact that you have the private actors can actually do their own tests, be controlled by public authorities while they do their own tests. We don't know yet how it will impact smaller structure and also the capacity and knowledge that exists in the hands of public authorities, which is very precious knowledge, especially for smaller structures. So the balancing act will give at least a lot of food for thought for months to come. And that is all on my end. And we'll take questions about this afterwards. But first, I want to introduce our 3 Croatian speakers, first thanking them for being here and giving us the time. I will start with Silvia, so that is the general flow of our program. So Silvia Kolar-Fodor is coordinator of the Croatian organization BioGarden in Harmony with Nature and a community seed bank. She's an organic gardener, educator, and the author of several books and texts about gardening and seed saving. And she will give us an overview of the 2021 national campaign, Seed is Our Human Right, which was led by 3 organizations. And Silvia, the floor and screen is yours.
Thank you, Julia. Okay, so do you see the presentation in full screen?
Perfect, yes.
Okay, so hello to everybody. And today I'm going to talk about initiative Seeds Are Our Human Rights. So it is about a change of the law on seed that started in Croatia in 2020. The first version of this law was sent to public consultation in December. And in that version was that farmers may use only certified seeds. So when we saw that something is really, really wrong, because it said that if farmers would produce their own seeds, it must be processed. And this version of the law was really harmful for the preservation of the old varieties and land races and for biodiversity. And also mandatory seed processing, it would be additional burden and administrative and financial, and it's not available for the farmers. So the founders of this initiative are Sunčana Pešek, Robert Hadžić, and me. And later to this initiative joined Maja Žulj-Mihaljević, PhD. And at that time, she worked at the Department for Plant Breeding at the Faculty of Agriculture in University of Zagreb. So she was our expert on seeds. And so what we have done? Well, first, we made invitation to citizens to respond to online public consultations. We sent letter to the Croatian Ministry of Agriculture where we have explained what that article actually means for human seeds as human rights. We sent letter to the media, and we started public advocacy campaign for changes to that law. We have involved experts in the public debate, and we really had high visibility in the media. We was in every television, radio, almost in every web portal. So after that big visibility, we had meetings with the Ministry of Agriculture, with the Parliamentary Committee of Agriculture, and political parties. So we were supported with public signature by over 135 associations from the Republic of Croatia and abroad. And that was together over 25,000 members. And also this supported also Croatian Chamber of Agriculture. And we had the signature of over 32,000 concerned citizens, farmers, and representatives of the scientific community. We also have a web page. And also we had one project, small. It was a small fund for active citizens in Croatia. But in that project, we had a couple of activities. First, we had roundtable about legislative frameworks for the preservation and development of the genetic diversity and of cultivated plants. We have two studies, survey studies on plant genetic diversity in Croatia and comparative study of laws in EU about seeds marketing. And also we had mobilization of farmers and citizens through direct action. We had a lecture during Croatia, seed exchanges, also a lot of campaign on social media. And it was one really interesting situation that happened to my NGO. So during that all campaign, this BioVert as a community seed bank, we have received 3 inspection and tax supervision during the process. Really extraordinary. It was right then. We don't know who sent, but it was then. So we had 2 court processes. We had fine because in Croatia it's impossible to fulfill all regulation. Because when you are okay in that law, but in second law you're not okay. Let's say like that. Laws are not aligned. So the work of the our BioVert Association and farmers related to seed preservation and also other associations here in Croatia, it's really hard to be financed from funds and tenders because we simply don't have it. So we were actually helped by donation from citizens. We have a lot of seeds and citizens were ready to give us donation for our work and we gave them seeds. But inspection said, no, that is marketing. And that's actually why we had fines. So how we are working today? So we are working via the Seed Keeper program, and what it's necessary that we have that people are members here, and by being member they can get seed. But unfortunately, it's often too complicated for people. People just want to have their seeds to get little donation or paid, and had nothing to do with the rest. So it's not really something that it's recognized in public. And what we were telling in that campaign, well, to preserve biodiversity in Croatia, it's necessary to ensure the right to seeds as a fundamental human right in the Croatian seed legislation. So we were also reading UNDROP and Article 19, and also to recognize and value the importance of freedom of choice. And with that first version of law, it wasn't like that. So what happened after all that big campaign? Well, the second version of the law on seeds, it was voted at the end of 2021, and it's in force from January 1st, 2022. So in new version, the obligation to use only certified seeds has been removed. And preserve and autochthon varieties and vegetable seeds has been removed from the obligatory seed processing. So now it's mandatory only for grain crops, oilseeds, and fiber crops. And agriculture producers whose total production area does not exceed 7 hectares are exempted from the obligation of processing also. But in comparison to European regulation related to breeders' rights, actually that law was compromised because in European Union, actually there are larger areas are for exemptions. So in the background, actually, during that process, we discovered that behind all that was not control of disease, like they told us at the beginning, but actually it was a regulation of breeding rights. And it's still a problem for seed processing for larger farms due to availability, costs, and administration. And it's not about, it's about seeds that are not marketed. So we see a big problem in that. It's only production for farmers and not for marketing of seeds. So seed processing includes drying, cleaning, calibration, peeling, treatment with plant protection agents, packaging, sealing, and labeling. And for farmer seeds, does not include packaging, sealing, and labeling. So not only, but farmer need to additionally to register as suppliers. And there is no processing service. So you can buy machines that are really expensive, but if you buy that machine, you cannot do also processing for a neighbor. No, you must be authorized, and it's also really big administration and financial part. So actually, it is something that farmers most likely wouldn't do because of that. So, and we see problem that actually the states with that controls something that the farmers does for its own needs, and it's not subject of the law. Law is on marketing of seeds, and we're talking about seeds for usage on farm. And so this is all from me. Suncha now will be telling you what happened next. And in the end, I would like to say that acknowledgement also goes to the institution for their cooperation, all association and citizens for their support, because actually I think we really, during this campaign, we made a big thing. Actually, we did change the law.
Thank you very, very much, Sylvia, for this inspiring talk. And without further ado, I will give the floor to Sunchana. I actually have questions, but I'll keep it for afterwards. I'll give the floor to Sunchana Peshak, who's program coordinator at the Croatian Organic Farmers Association Alliance, HSEP, and a coordinator of the On-Farm Seed Conservation Model, a cooperation between farmers and the National Seed Bank. She has a long experience in seed saving, civil society, advocacy activities, and educational ones. And she will present to us the changes that were made to the Croatian seed law, which we got a glimpse of, and the cooperation models that were introduced following the campaign. She will also highlight the concerns and interests of Croatian seed savers in the context of the ongoing seed reform, And after, we'll give the floor to the farmer of this talk today. Sunchana, the floor is yours. If I can find you. Sunchana? Maybe you're muted. I can't see you anymore, so yeah.
Yeah, I apologize. Yeah,
No problem.
yeah, I was hurried to share the presentation. So I forgot to do that. So just a second. Okay. No, I'm sorry.
It's coming, don't worry. I think it's the connection.
Maybe I'm also living in the village. I'm really grateful to be here. I will try again. Sorry. No, it was working just a while ago, and I don't know.
Maybe it was
happening.
working.
Well, maybe
it was working when your camera was off. So maybe if you put your camera off and try again, that might work.
maybe I could do without presentation. It's not so big anyway. So I wanted to introduce what happened after our campaign about cities are human rights, and it took a while after all the regulations were fixed according to everything that was going on European level, following European directives, and also following the new changes in the seed law. And the biggest change now is that now we have on the Croatian level also the regulation on processing of the seeds of the farm safe seeds, which is unique inside of European Union, and we think it was kind of a compromise that we made during the campaign, and which was interesting. During the process of adoption this regulation, there was representatives of the companies, seed companies from Croatia, and they said very openly that the background of all this process was actually their inability to regulate the breeders' rights that they're having to their varieties that are protected, and it was a big problem for them because they are losing a lot of money like this, and it is very problematic to mix to have such a mixture of law that's supposed to regulate the seed marketing and the production, but in the practice we have quite a mixture of plant breeders' rights and also mixture with the rights of plant health. So although, as Fulia explained, it is on European level quite divided, but in the practice it often happens. It is a very important issue in that we are facing. So there are different rules even for the saving seeds on the farm now, and register as a producer, and then the marketing rules said something else. Mario will explain more about it, what kind of problem was he facing, and also the other farmers who started seed production in Croatia. So also what is different in Croatia now than in the other countries is that now we have a new variety list because the campaign brought a lot of attention to this issue of preserving traditional varieties and farm safe seeds, and it was important to us to minimize the burden on the farmer and motivate them to register as seed producers, because it was quite a complex procedure before. We had the obligation for farmer to have a professional person who needs to work on the farm full-time employed, and none of the farmers couldn't do that. So they were always making up some kind of fake agreements and trying to find a way how to start their own seed production, and quite not many of them adapted all that rules and managed to apply to as a seed producers. As the result, we don't have organic seed production almost at all. There nowadays we have just a few farmers who are starting the seed production, and also the rules were quite different even for the standard seeds, because in European Union, for example, in standard seeds you don't need to have seed certification system, so it's lighter rules on that. But in Croatia we had quite strict rules, and as a result the seeds are coming from the import. So we have a more strict rules, and then we are importing the seeds that are produced in the less strict rules, and we are adopting them as quite good enough. So then why wouldn't we apply the same regime in Croatia and enhance our seed production? And it is, of course, the very big part of our resilience and also our farming in general. Seed is the very beginning of farming. So it was very important for us to minimize the rules in the laws, and in the conversation with the people from Ministry of Agriculture and other institutions, they came up with the proposal of that new plant variety list that will be only valid in the Croatia, but it will also simplify the procedure of registration traditional varieties, because nowadays we have a regime for the conservation varieties, which is not quite simple. Like, for example, there is a rule that every variety that is registered like this need to comply some standards for uniformity, not completely like the other varieties, but there is some requirements. Also, they need to give historical proof that this variety was here like 15 or 30 years ago, depends which variety we're talking about. And it's quite hard to find. Like most of the seeds, for example, for vegetable seeds, they were just called like domestic carrot or domestic cabbage or domestic something. People didn't even came up with a special name for it, because it was seeds that was just exchanged among the farmers, and the farm safe seeds were like basic in many rural areas of the production, especially in vegetables, but also other grains and other crops they were having. So sometimes it is quite hard to find those historical evidence. In some varieties, people took a lot of effort to do that. And in the end, the thing that is happening right now is that the agency who is maintaining the variety list in Croatia, they started to clean sort of the list. They are checking now are the rules followed still, and they found out that for many traditional varieties that are registered as conservation varieties, we don't have producers anymore. So we need to delete them from that list. So after all this effort and everything, now we, thanks to that strict rules that we had before, we don't have a producers who producing them. So now we need to do it all over again. So by now we have like only 27 varieties on that list. I think the other European countries are not much better, so it's not like it's a small number, but the others I think have similar problems as we have. So we needed some lighter rules. Also the rules for the amateur varieties, which are the varieties for growing in under the special conditions. That category in Croatia did not lived in practice. Because nowadays we have farmers didn't even try to use that, and it was very hard for the institutions to find the right explanation. What kind of varieties would that be? Is it the varieties for small gardens, or is it varieties for just special I don't know, mountain tops or special areas that that farmers can grow only special kind of varieties, and we didn't know what to do with it. Now it's the rules are cleared, but still I think the farmers will find more better ways to register heterogeneous material or to register varieties in that new variety list. So it was very good, I believe, the cooperation between us as an organization, civil society organization, and the farmers and the representatives of the farmers, and also on the other hand, institutions who also see the problem, and who they were quite willing to cooperate with us and find ways how to assure the conservation of traditional varieties and all the other varieties that we have in our villages that are part of genetic diversity. And thanks to that, we started also now from this year 2 models that are introduced to the farmers. So first model is a model of on-farm conservation of plant genetic resources for food and agriculture. We have our national programs, same like in the other countries. It's actually ruled by is drafted by FAO, and all the other countries are adopting it. So we are also part of that. And as an organization, Croatian Alliance of Organic Farmers is organizing the farmers who adopted some varieties from the National Seed Bank as a sort of like on-farm model. The difference between the ex situ conservation that we usually had, it is the conservation of traditional varieties inside of the seed banks and in the frames of the special institutions who are taking care of them. We are now have a program that farmers can participate and they can access the seed from the National Seed Bank, which we see as quite a big treasure. It's not really useful if we have a national seed bank that its only purpose is to save seeds and to store them in the ice chambers, and they never see the daylight again. So we wanted those seeds to live, we wanted them back on the fields, and we wanted farmers to experiment with those seeds. And it's especially interest of organic farmers who grow special kind of material. And as I mentioned before, we don't have so much of the organic seeds production. We also need to find our own ways also in organic breeding, because we don't have that basic material. So the traditional varieties can be a very good basic material for further breeding in organic farming. So that is why it is also helpful to have such a program. The second program that we have is direct support of the institution involved in this seed bank and the national program for conservation of traditional varieties to the production. Because the institution multiplied, several institutions were involved in multiplying the seeds that were now the basic seeds for the farmers to start their own seed production. And that was the way to overcome the lack of the farmers who are taking care of those varieties that are registered on the variety list as a conservation variety. So part of those varieties are conservation varieties, and we're trying to find the farmers who will actually save them from being deleted from the variety list. And we are also trying to help farmers to start their own seed production, because it's a special knowledge they need. It's a little bit different to produce for their own needs, and it's different to produce for the market. And it is we are very grateful actually to have such program that we can test those varieties from the seed bank, and we can also start the seed production. As a civil society organization, we also started some projects between the farmers to organize education and everything that they need to start the seed production. And in that context, what we need from the EU reform is to recognize the importance of the small-scale farmers in the supplying in the seed supply, as well as for their own needs and also for the local market. In Croatia, it is especially important because, as I said, we don't have so much seed production. So it is very, very important for us to enhance this production and to motivate people. And further complication of all the rules and regulation is definitely not helpful. And also, what is not helpful is additional administrative burdens. So we would like to have the seed reform that will be simple and clear for the farmer, and that will make simple and clear rules in all the levels. So like combining all the regulations for plant health and the seed breeders' rights and also the production and trade. It needs to be in the same level, sort of. So if one regulation asks you for something, another cannot ask for more or for some other things. So for farmers, it needs to be simple and clear so they can apply all these rules and adopt them in practice. So without further, I will give now the word to Mario Juretic. Maybe
I
Julia,
will
you want
present
to
him, yes.
present him? Yeah.
Thank you so much, Sunchana, and thank you for ending on your needs and interests for the future seed reform. And I love the fact that you're talking about harmonization of seed laws, because in fields and gardens, I mean, laws don't come in separate boxes or separate plots. They all find each other in the same square meter applied on top of one another. So I'll give the floor to someone who's juggling with all of this in his farm. So Mario Juretic is a farmer, agronomist, and one of Croatia's first organic seed producers, with a special interest in traditional varieties and breeds. From the position of a farmer and beneficiary in the new on-farm conservation model that Sunchana talked about, he will highlight the opportunities and obstacles to seed saving and production by Croatian farmers. Thank you so much for being here. It's a pleasure to hear you speak on your rights and the difficulties you face. Thank you, Mario. The floor is yours.
Thank you. Hello, everybody, and thank you for the invitation for this meeting. I will talking about some problems at the ground. We have for producers who encounter in the regulations governing the field of seeds production for the first time, they became completely confused, because these regulations are not aligned with the situation on the ground. For example, the phytosanitary regulation requires some that is not prescribed by law. For example, they required the additional documentation of on the knowledge of quarantine pests that I passed during my study, and in the plant protection course. And then phytosanitary, they don't recognize that term. They don't give a specific answer to the question where it can be disposed. That is, the answer is contact the agency. After the contact agency, I get a reply that it is recognized because I have passed through the plant protection course with minimum of 19 school hours. That is something playing football with us. So we have complicated rules. In my opinion, it is necessary to agree precisely what is needed from the documentation. Actually, on the end, I'm sorry. What pleases me is the production of old varieties, which in most cases have proven to be more resistant to stressful climatic conditions. Thus, crop of some old varieties of corn on my farm showed exceptional tolerance to drought last year, while tall beans completely aborted under field condition without irrigation. When selling old seed varieties, the limitation factor is that you have to be in the register of seed suppliers in our country. In the case of varieties that are not systemized, but have been produced for centuries. So are they amateur seeds, or what? I don't know. That is some question for you, if you can put it in some system. For our small producers, the current regulation make it difficult to do business. So I suggest that some kind of models be found for us, our smaller farmer. So I'm very short, but I think that I have the main problem of legislative for our who we are for us who can who try to save the old varieties of the seeds. So thank you.
No, thank you very much. It's great to know the path that you had to follow to become or to try to become a seed producer. Yeah, and you had a little thing on a question on the amateur varieties. I'm actually also surprised that you don't have a lot in Croatia, because it's the regime that's used the most, like in totals. If you look at all the conservation varieties that are registered around Europe, you're about at 400 something. For agricultural species, and it's I think so low for vegetables. I think it's 100 something, not even 190 for vegetable conservation varieties, whereas for amateur varieties we're about 800 something. So it's much higher in general. So, and it's easier to get access because in most member states, for the registration of amateur varieties, they don't ask for DOS tests, or not even adapted DOS tests, and the registration process does not include a reference to UPOV protocols, even if they're adapted, which is the case for conservation varieties. So and for just as an example, I think it speaks volumes to the impact the national authorities approach and the national law can have. So on the 400 conservation varieties that are registered in Europe in agricultural crop species, 150 of them only come from Sweden and Italy. 2 countries make 150 of them, so it shows. And you have a lot of countries where there's 0, like in Austria, there's 0. So it's just in Denmark, I think they have now 1 or 2 that they've done, but so but because everything is registered somewhere else, the countries change their approach.
Okay, I have a conclusion. We are on the beginning, and we have a chance to make all of these species on the short list.
Yeah, I think the idea of this reform for the Commission, at least for seed marketing, is to have one regime, like a single regime, where you could put like everything, all the material that is not really DOS. you know, so to have one door, one market entry, like road that you could use if what you are conserving, producing, maintaining, breeding, developing, it could be anything, it could be something new as well. If it's not DUS, so if it's not distinct, uniform, stable, you can use that route. And if what you're breeding is and you want to produce is DUS, distinct, uniform, stable, you will have the highway that is already applicable every day. So that's the idea.
Yeah, okay. Thank you.
Maybe I could add also. Yeah, I think in Croatia there was sort of like a fear from traditional varieties until nowadays, because they are I don't know why, I cannot explain, but the rules were quite strict, and these amateur varieties were introduced into the law quite recently. Not in this reform, but a little bit before, but still the rules were not clean completely, and it was not clear, not even in the law itself, and for farmers, especially for farmers. Most of the farmers don't even trying to register their varieties, because for them it's quite unknown procedure, and most of the conservation varieties that were registered, they were registered by the effort of people from different institutions. For example, we had one man who worked a lot on registration of such varieties, and he was helping farmers a lot to put them on the list. And sometimes it even happened that farmers even didn't know that their varieties are on the variety list. I had the funny story with my very close friend of mine. She's a farmer, and she was growing some varieties of tomatoes, and I found while I was searching through the variety list, I found her name, that she registered variety from her island that she's producing, and this variety is on the variety list. And so I called her and I asked her, so I didn't know you were a producer, you are like an official producer. And she said, no, I didn't know as well.
So she was a maintainer. She was the maintainer of the variety.
She was the maintainer, and she was registered as a producer, the only producer that's supposed to take care of this variety. And she does that for her own need, but she didn't register the production, and she didn't even know that the variety was registered. So like, even if the varieties are registered, farmers sometimes didn't know, because they didn't even think about registering the seed production. It was just not an option for them. The rules were strict, and they just they didn't think about it. So it is very important for us to open some kind of simple rules that would motivate farmers to be the part of the market, because I think they're very important, and to assure also the resilience of the farming system, because the changes in the climate and everything that farmers are facing today, they are quite significant, and every year is different. Like last year we had a big drought, this year we had a lot of rain, enormously a lot of rain. So you can never know, you can never adapt with anything. So like we need to have the diversity to go ahead with to just to survive. So it's very important to adapt the rules to the things that are happening in the practice, not the other way around.
Yeah, thank you very much. I'm gonna take, so if anyone from the audience would like to take the floor and ask a question, or use the chat if you don't want to ask it orally.
Yeah.
Now
or
is
maybe
the time.
add something, because we have I think
of course we can.
members from our Ministry of Agriculture, and maybe they want to add something that we forgot.
That's
Can
Yes,
I add something?
yes.
Yeah, I will be really short. All the talk about traditional varieties, that is really, really, really important. But I want to kind of point out of new modern land races. I mean, basically, that's how traditional varieties happened centuries ago. I think we should also, those modern land races, locally adapted, we should also put them in the same kind of group with the traditional varieties. I mean, that's my own personal thing, let's say.
I mean, there are so many publications on what a landrace is, what the traditional varieties, and I think from people to people it changes, not even from country to country. And I think, but the idea of the commission with this new reform and the new regime they will come up with, hopefully, is that it would embody not only old varieties, traditional landrace, however you call it, and also new ones, like, you know, the heterogeneous populations, the new material that can come out also. And that's, I think that's also an interesting thing, the recognition of farmer innovation, which is in UNDROP, that it's not a static.
Of course, because Sunčana just mentioned it, these varieties in climate, in different conditions, local, regional. We have 1 year it's a drought, next year it's a very rainy. We have also a large shifts in weather in short periods, not just year from year, but month to month. We shouldn't be that much, let's say, focused on keep our seeds uniform, pure, or whatever, but seeds should change with us and with our management and with our land. That's the point.
But you should know that is a nightmare for public policy. Something that changes and that you can't regulate as is. It's a nightmare, honestly. So.
I know, that's why I do guerrilla seed sharing in my region.
Someone wanted to add something. I saw someone unmute themselves, but they couldn't.
Hello, everybody. Do you hear me?
Yes, we do.
Yes, my name is Ivica Delic, and I'm speaking from the Ministry of Agriculture. Just want to add to everybody, first of all, thank you for invitation. And another things are, if we're talking about your presentation today, very interesting presentation. Thank you for everybody for cooperation. But if we look at for the Ministry of Agriculture, if you look at for the side of the legislation, I think that's the main problem is in the EU legislation, which is very old and it is not so clear. It is not so clear what we need to do if we're talking about the legal department, if you're talking about the growers. But as colleague Mario said before, we are on the beginning. I think that's the new PRM regulation, which we accepted very soon. I think that will be very much and wider area for the growers, especially if you're talking about the old varieties. So just want to add, we are still waiting for the new legislation. I think it's be much better and much more clear for the future. Just that. Thank you.
Thank you so much for your presence and comments. And maybe just to add as a point of illustration, so we talked about the conservation varieties regime. The first attempt of the Commission was in 1998. They adopted the Commission directives on conservation varieties. It absolutely didn't work because member states didn't know what to do with the thing that was adopted, you know, and so they were thought about, and in 2008 a new set of directives, Commission directives that we know today, got adopted. So it took them 10 years, you know, so it's a work in process, definitely.
Yes, we noticed that, we know that, but if you're talking about the national legislation in Croatia, maybe 2 months ago we put some ordinance about the old varieties, conservation varieties, old about, if you're talking about the old varieties vegetables, or the first, on the beginning it will be vegetables. And I think that's we put much more easier the path to be the old varieties on the national list. And if you want to market today the main problem I think it's because in the national legislation and the national producing system, because we don't have the lots of people which are interesting for produce the old varieties. That's the main problem. We don't have interest. We can put the lots of subsidy and everything, but the people, they don't want to produce much more old varieties and put on the market. Only they put to own self. We are talking about the little quantities of seeds. We are talking about the little quantities of fruits. So it is not so easy, and it's very complicated. If you're talking about organic produce seed, today it's the big problem in all countries in Europe, not only in Croatian. I was 2 days ago in the Belgrade. I was in the Macedonia. They also in the Bosnia and Herzegovina. Also, they have problem if you're talking about the organic producer of seed. All of them, they have the similar problem as we have here in Croatian or the other colleagues in the most of the EU countries.
Thank you very much for your comment. Does anyone want to react? Mario, I saw you. Yeah.
Okay, thank you. Thank you, Ivica, for good news. And I'm looking that my entrepreneur with that old seeds varieties like business chance. So if we put it some on lower step, or no, not lower, higher step, I think maybe we have much more interested around the people. When I traveling through the Bosnia and Herzegovina, and my colleagues, it is the ocean of the old seeds, old sorts, and it is a chance. It is a chance to catch them old, because it is. That is the bank of genes, or variety of genes, and I don't want, and everybody don't want to lose that. But the first, if it is have a chance to get to take that on a business level. Thank you.
Sylvia, you wanted to react to
Yeah, I would like to add something. It's like, what was first, chicken or the egg? So yes, it's really not enough of interest, but because there was really a lot of bad laws. So it wasn't interested, because for production of seeds or for being organic farmer. I'm not organic farmer on paper. I am working organically, but there's so crazy group of laws in Croatia. So one of those is I'm too biodiverse. So my farm is too biodiverse, and I would have problem if I would be in that system. So I choose not to be in that system because it's easier for me. I don't have time for administration. So it's also, I think, in the seed producing, if we have better laws, I believe we will have increasing of interest.
So more adapted laws, not just on registration, but also seed production.
Yeah.
So you
Also,
mentioned standard, and the standard seed will be more widely used normally in the new EU rules. That's what they envisage, but I stopped. You wanted to add something?
No, I would like just add. So today I have 3 business models. I mean, I'm farmer. I have a firm business, and I also work in NGO. And we have so many laws, and you are really breaking one law by complying the other. So I have to work everything. I work through three different models to actually be able to work everything I'm doing. Like NGO association, it's not allowed to have online sale. NGO in Croatia cannot have web shop. It's breaking the marketing law. It's crazy, but it's like that.
The marketing or the plant health? The plant health legislation, maybe.
No, okay, it's plant health. Yeah, when you have that, but you cannot have a web shop. It's crazy law. So I have to have company to make online sale. So we're talking really about really a lot of amount of bad laws that need to be aligned, not just
So it's alignment and coherence.
Yeah.
Yeah. But that, I'm sorry to say, that might not only come from this reform, but the UNDROP, the way it's structured, usually it calls for this alignment and coherence. So maybe something on the governance could help. Like if all of these legislation and all of the departments in public authorities and also control bodies talk to one another in one big group. Also including farmers, CSOs, but also the seed industry. So everyone needs to sit down together and talk. I think that might ensure more coherence. And with that, we're actually over the time. Karine, would you like to, or Christophe, would you like to conclude? Yes, Christophe, please.
Thank you very much. No, so that was extremely lively, and it's also good to see that you have used the Article 19 of the Declaration in your work in Croatia. And I remember that at that time we were in contact with Sunkana. And so that's it's great. So it was great to come back with you and discuss about this issue in Croatia, and we hope that we will continue this research project for 2 more years. And so we hope to come back to you after the proposal by the European Commission and to see how it can be implemented then on the national level. So thank you very much, everyone, for a very participatory and very rich discussion. Bye-bye, everyone.
Thank you, everyone. We'll send you all the video recording will be available on the Geneva Academy website, and the presentations which were made also, if any. Thank you so much.
Bye-bye.
Thank you.
Bye.
Thank you. Bye.
Bye.
Thanks. Bye.
Thank you. Bye.